morning and thank you for joining us for this webinar, Litigating Social Media, a Defamation Labyrinth. I'm Athalie Matthews and I'm Counsel in the Reputation Management team here at Farrer & Co, an independent London firm of solicitors founded in 1701. I sit within the firm's dispute resolution practice and I advise both claimants and defendants on contentious matters relating to defamation, privacy, breach of confidence, data protection and harassment. More widely, my firm has a very lively and international disputes practice, encompassing everything from corporate and shareholder disputes, fraud and asset recovery, data protection, IP and technology, to commercial property, international arbitration, employment, art and cultural property, sovereign and diplomatic disputes, family law, and contentious trusts and estates. We therefore certainly qualify as enthusiastic participants in London International Disputes Week, and it's very nice to see people tuning in from both the UK and foreign jurisdictions. I'm delighted to welcome Adrienne Page Counsel, who's Joint Head of Chambers at 5RB, a leading set of barristers in London, specialising in media and communications law, and with whom my firm works very closely. Widely recognised as one of the foremost silks in her field, Adrienne represents both claimants and defendants in high-profile disputes. Adrienne is rated as a star individual in the defamation and privacy category of Chambers and Partners, and in 2024 was the Legal 500's Media and the Arts Silk of the Year. Her extensive experience includes appearances in the only two cases in which the UK Supreme Court has considered the provisions of the Defamation Act 2013, Serafin and Malkovich and Lashow versus Independent Print Limited. She recently acted for MGN Limited, publisher of the Mirror newspaper, successfully defending them at trial against Sir James Dyson's high-profile libel claim.
Thank you for that very flattering introduction, Athalie, and I'm delighted to be taking part. Obviously, many of the disputes that we both work on have an international dimension. We have very strong relationships with lawyers located all around the world, including some, I believe, who are joining today. I say thank you, I would say, to everybody for joining this discussion. We hope our audience will find it informative and entertaining. For local specialist lawyers, some of what we talk about will be very familiar, but we do need to provide a bit of basic information for those in the audience who are less familiar with how English defamation law works.
So I should just mention we're going to talk for about 45 minutes and the webinar is set up with audience microphones off, but you'd of course be very, very welcome to contact either of us with any questions after the session if you'd like to. So as you know, we're going to talk about the topic of defamation litigation arising from the things people say on social media. First of all, we'll look at the fact that litigation in this area is on the rise and why that might be. Then we'll explain, for those unfamiliar with the area, some key elements of the law before going on to look at a couple of contrasting cases in a little more detail to show you an example of what a labyrinth the issues can become and whether the established principles of defamation law are still suited to the task of unpicking them. The kind of social media posts that people sue over can look relatively short and straightforward, but appearances can be deceptive. These kind of cases can actually raise legal and evidential issues which are challenging to litigate. These days, a short post on Instagram or Twitter can result in a High Court trial and a 75-page legal judgment, and sometimes go all the way to the Supreme Court, the highest court in the land. But the cost and complexity of bringing this kind of claim doesn't seem to be deterring claimants, because we're seeing a rise in these kind of cases, aren't we, Adrienne?
Well, we're definitely, I would say, seeing a shift in the nature of the cases that come before the courts. There was a time when the cases involving mass publication involved complaints over publications in the mainstream traditional media, such as, for example, a libel claim against a major UK newspaper like The Times, the Daily Mail, or a national broadcaster. But now, when one looks through the list of cases over recent years involving damages awards for defamation, one sees a large number that refer to allegations published by individuals on social media posts. And this shift reflects the fact, of course, that mass publication used to be the exclusive preserve of the national and local media, much of it regulated or self-regulated, most of it involving professionally trained journalists and editors, pre-publication involvement of in-house legal departments or other specialist legal advice, defamation insurance in some cases, and certainly an experience, or at least a strong awareness on the part of publishers of the legal risks. But there has been a fundamental change in the landscape. There are a number of course, very obvious reasons for this. Firstly, of course, the sheer number of people now using social media for personal and business reasons, but also in some cases a means whereby individuals without necessarily any sophisticated understanding of the law, wanting to communicate their unfiltered opinions and allegations to the world at large, often individuals who are happy to seize the megaphone to broadcast whatever is in their minds in the moment to the widest audience they can command, armchair politicians, gossip mongers, self-styled influencers, people with a grievance, and so on. And the audience for some of these new citizen publishers is frequently on the scale or far beyond that of the old print editions of the mainstream national newspapers, or even of some of the online editions today of the traditional news outlets. A social media audience can stretch into millions in some cases. Combined with the extensive reach potential of social media, citizen mass publication has facilitated a more fluid and off-the-cuff style of public discourse and communication, often leading to more rhetorical, unguarded, intemperate statements and ripostes, reckless, heat-of-the-moment exchanges which not infrequently may be defamatory of others. The list of recent cases in which damages awards have been made against individuals who've posted on social media includes some extraordinarily serious allegations: fraud and dishonesty, corruption, paedophilia, child grooming, rape, allegations that would not have featured in mass publication cases before the internet era, other than, one would hope at any rate, after the most careful investigation and legal advice by professional journalists and traditional newspaper publishers.
Yes, it's all very unfiltered. And to make matters worse, many people engaging in conversation on social media in this way is very off the cuff, and they just don't realise that what they're doing could land them in court with a defamation claim and a potential liability in damages and costs, which is easily sufficient to bankrupt the ordinary person. Damages awards against individual defendants in social media cases can be in the tens of thousands of pounds and even up to and over £100,000. And on top of being awarded to pay the claimant a sum in damages, a losing defendant will have liability for legal costs, and the damages are often dwarfed by the costs. So an unguarded moment, venting your spleen via your laptop keyboard or your mobile phone, really can have life-changing consequences and certainly make a very large hole in your bank balance.
Certainly, yes, life-changing consequences is a good way of putting it. Because of course it doesn't help to say that you didn't mean to defame someone. Defamation in England is a strict liability tort. That's to say, the actionable wrong is simply the act of publication to a third party of matter that is defamatory of the complainant. The liability of the person publishing or participating in the publication of defamatory matter does not depend on proof that they intended to defame a third party, or that they even knew that what they published might do so. In other words, there's no requirement for fault or intent on the part of the publisher. Another potent aspect of publication by social media for present purposes is the potential for what is published to be amplified by rapid, instant republication. We used to have a saying that today's news is tomorrow's fish and chips paper, meaning that newspaper headlines will often be forgotten the next day. This doesn't apply to publications on social media, which can go viral and both spread and be later retrievable rather than just fading away. Although, of course, the rapid turnover of social media posts may mean that damaging publications are swiftly buried by the quick-fire exchanges that follow. It all depends on the circumstances. But of course, we must remember that retweets, shares, comments can all carry liability if they repeat or republish defamatory material. So it's not just the original poster who needs to beware.
Thanks, Adrienne. That provides really interesting context to the phenomenon. So we'll move on now to look at a few of the key principles of defamation law in this jurisdiction, i.e. England and Wales, and look at a couple of illustrative cases. We hope this will be useful for those of you listening from other jurisdictions, bearing in mind that the way jurisdiction works in defamation is that foreign claimants can sue in the courts of England and Wales where a publisher, i.e. a person posting a social media post, is based here. So someone located in England who posts something on Facebook or Twitter could be sued for defamation in the London High Court by a foreign company or person, provided certain criteria are met.
That's correct. There's no impediment to foreign individuals or corporates suing a party based here for defamation, subject, of course, to the same procedural and evidential hurdles as an English claimant. But if the foreign claimant can't demonstrate a substantial connection with or reputation in this country, they may find their claim being challenged either on the ground they cannot demonstrate serious harm to reputation here, or as an abuse of the legal process as it's described, on the basis that to sue for defamation here would not serve the legitimate purpose of vindicating their reputation here. But any claimant, whether based in or outside the jurisdiction, has to demonstrate that the offending publication caused serious harm to their reputation or is likely to do so. In the case of a corporate entity, there is an additional hurdle to overcome, which is that serious harm to its reputation caused or was likely to cause it serious financial loss. That is a statutory requirement that came into effect as recently as the 2013 Defamation Act, and which has made it much harder for companies to bring defamation claims here, and to some extent also for individuals, although they don't have to show serious financial loss, because even if the overseas claimant can point to some demonstration of serious harm to their reputation, the question may arise, was the harm suffered here or elsewhere, depending, of course, on how the action is framed.
Yes, and we should, of course, preface this discussion by pointing out that the law of libel here involves the same rules, whether it's social media or any other publication in permanent form, like a newspaper or a magazine or a television programme.
That's true. These are rules that were, for the most part, developed by the judges over a long period of time, going back long before the advent of the internet. But now that the ability to make a mass publication rests in the hands of any and every private individual who seeks to do so, armed with no more than a mobile phone, some of these rules are being challenged. There is an example of where that may be apparent in a case we'll come to mention where there's an appeal to be heard in the Court of Appeal next month.
Yes, so first of all, let's take a quick look at who can sue for defamation on social media and who can be sued for a social media post. So let's start with who can sue for defamation.
Well, any individual or corporate entity can, in principle, sue for defamation. And by corporate entity, I mean a juristic person. So, for instance, in this jurisdiction, an unincorporated association cannot sue for defamation. The proper party to bring the claim is the party who can demonstrate they have been defamed by the offending publication. That is to say, either named directly or identifiable in some manner, such that all or a substantial number of the publishees would understand them to be referred to in a defamatory sense by the words or images that have been published.
Yeah, and then looking at who can be sued, essentially the law says that the author, editor or publisher of a publication is the entity that can be sued. And in the context of social media, that basically means the person who posts the social media post is liable for its publication, as is anyone who's involved in creating it. For example, if someone created some sort of content for the person to post, if they knew that that's what it was going to be for.
Section 10 of the Defamation Act 2013 is important here because that provides that the court does not have jurisdiction to try an action for defamation brought against a person who is not the author, editor, or publisher of the offending statement, unless the court is satisfied that it's not reasonably practical for an action to be brought against the author, editor, or publisher. In the context of the types of social media cases that have been coming before the courts, the host platforms such as Facebook and Twitter are not considered to be authors, editors, or publishers. But of course, the platform or host can, of course, be approached to take the material down or to provide information about the party that actually posted the offending item. And under the same Act of 2013, the court can order a website operator to remove defamatory material once the court has given judgment for the claimant in a defamation claim against the author, editor, or publisher.
Yes. And I think it's also really worth mentioning that we've actually seen a case where the claimant, a businessman who's called Mr. Munir, chose not to sue the person who wrote and posted the defamatory post, but the individual who, it was established in the case, controlled the social media account in question and could have taken it down once he knew about it. So this was the 2018 case of Zahir Munir versus Steve Wood. It's very much worth bearing in mind for anyone who controls a social media account that other people have access to. So moving on to the procedure for a defamation claim to be brought, there's a fairly formal approach required in the lead up to a defamation claim. And in 2017, the High Court established a specialist list for the management and determination of media claims by specialist judges, which are known as the Media and Communications List, and the conduct of such claims has become quite streamlined procedurally. Also, whereas once we had juries to decide defamation claims, we effectively lost the jury system with the 2013 Act. So claims are decided by judges, and that's opened up some procedural shortcuts.
Yes, but of course, before we even get to launching a defamation claim, there is a requirement under the current procedural rules to send a formal letter to the proposed defendant pursuant to a protocol which states what information should be provided by the complainant and what information should be contained in the proposed defendant's response. It's a process intended to bring about an exchange of information that may help the parties to resolve the dispute before proceedings are commenced. If it doesn't achieve that, then the next stage is to issue and serve the claim form with or followed by particulars of claim setting out the full detail of the claimant's claim. And of course, we mustn't forget that in this jurisdiction, the claim form has a limitation period of 1 year, so it has to be issued within 1 year of the offending publication or the first appearance of the offending publication.
Yes, and a year might sound like a long time, but it's actually relatively short compared to other limitation periods. And also in this jurisdiction, our courts generally get actively involved in the case pretty early on, doesn't it?
Yes, if there is a dispute between the parties, and this will usually have emerged during the pre-action correspondence, about some of the elements of the claim, there is a procedure for having these disputes determined by the court at the earliest opportunity, which is usually before service of the defence, wherever possible it will be before service of the defence. The idea is to decide what can be decided by the court ahead of the defence, and that avoids costs in the longer term. And the principal determination that the courts make before defence are about what the meaning of the post is. In other words, what is the meaning that would be conveyed to the reasonable reader, the single meaning, and I'll come back to that, and whether in that meaning the statement complained of was defamatory of the claimant. So English law determines the questions of whether the offending statement refers or would be understood to refer to the claimant, and if so, whether it defames the claimant through a process which is objective and abstract. There are exceptions to everything, but in the general run of cases, the court does not receive evidence of what actual readers understood by the words, or, as we've already highlighted, what the publisher intended his words to convey. The court determines these very important questions through the lens of the hypothetical, ordinary, reasonable reader of the statement in question. The question posed and answered by the court is, what would the words convey to the ordinary, reasonable reader as to who is referred to in the words and as to what meaning is conveyed about them? And then, having ascertained the meaning of the words in that objective manner, distanced from the actual surrounding facts, the court then decides whether in that meaning, the words would have been understood by readers in a defamatory sense. That is to say, in a meaning that it attributes to the claimant behaviour or views that are contrary to common shared values of our society and that have the tendency to have a, and I quote, substantially adverse effect, end of quote, on people's attitude to or treatment of the claimant. Another common area of dispute is whether the statement complained of was expressed so as to convey to the hypothetical reasonable reader that the claimant was definitely guilty of whatever misconduct was in question, or whether it was phrased to mean they were merely suspected of it. And we call this looking at the level of the defamatory meaning, the gravity of the defamatory meaning. Saying someone is guilty of something is obviously more serious than suggesting that they are suspected of it. And the means of defending a statement of truth will vary by a statement with a defence of truth will vary according to the level of the meaning, as will the likely damages award. Another key issue the court determines early on is whether the statement published was simply an expression of the defendant's opinion or an allegation by the defendant of objective fact about the claimant. The law treats fact and opinion differently, and decisions on this issue will determine what defences can be employed. A lot of cases settle after these early determinations are made. This is because they are key disputes, the outcomes of which are likely to affect strength or weakness of claim or defence, and which may rule in or rule out the use of particular defences. There is another important hurdle for a claimant, which is the need to prove serious harm to reputation from the offending publication, as I've already mentioned, and in the case of a corporate entity, consequential serious financial loss. But other than in very clear and obvious cases where there really is no factual dispute to be determined, this is an issue now that's usually left to trial.
Yes. Thank you for that. And one of the recent social media cases we thought it would be interesting to mention is the case of Andrew Bridgen versus Matthew Hancock. At the time of publication, both men were members of Parliament for the same political party, the Conservative Party, although both have since ceased to be MPs. This was a case of a tweet by Mr. Bridgen, to which Mr. Hancock responded with an angry tweet of his own. Mr. Bridgen then sued Mr. Hancock for his response tweet. This is, so far as we know, a case which is still ongoing and in which there have been 2 court determinations prior to service of the defence. Just to set the scene, Matt Hancock, the defendant, was the Secretary of State for Health in the British government throughout the COVID crisis. It was a period marked by rapid development of vaccines and the launch of mass vaccination programmes. In 2023, Mr. Bridgen tweeted a link to an article suggesting that a US study indicated links between vaccination and a range of serious adverse health effects. He was worried about the vaccination. His tweet said, "As one consultant cardiologist said to me, this is the biggest crime against humanity since the Holocaust." Later that day in Parliament, Mr. Hancock asked the Prime Minister whether he, the Prime Minister, agreed. Thus I quote, "The disgusting, anti-Semitic, anti-vax conspiracy theories that have been promulgated online this morning are not only deeply offensive, but anti-scientific and have no place in this House or in our wider society." The Prime Minister duly responded in agreement.
Well, that would all have been fine, of course, if Matt Hancock had left it there. The words spoken by him in Parliament have absolute immunity. He couldn't have been sued by Mr. Bridgen for those words uttered by him in the House of Commons. But of course, he didn't leave it there, did he?
No, he did not. Hancock followed up by sending out a tweet. It contained a video clip of the parliamentary exchange we've just talked about, with text that read, "The disgusting and dangerous anti-Semitic, anti-vax, anti-scientific conspiracy theories spouted by a spitting MP this morning are unacceptable and have absolutely no place in our society." So, Adrienne, what has the court ruled so far, and why do you think it might be significant for how the case develops?
Well, so Matt Hancock, as you heard referred to, simply a sitting MP who he didn't name, and there are 650 sitting MPs in House of Commons. But the tweet did refer to the sitting MP as having spouted that morning and did identify what he was spouting about. So the case raised the issue of reference. Would reasonable readers of Mr. Hancock's tweet understand him to be referring to this particular MP, Mr. Bridgen? And the court ruled, unsurprisingly, that Mr. Bridgen would have to prove that there had been a body of readers of Mr. Hancock's tweet who had pre-existing knowledge of Mr. Bridgen's relevant activities, including, for instance, that he had spouted that morning. And that meant that they would have then understood Mr. Hancock to be referring to Mr. Bridgen. Now, whether or not Mr. Bridgen succeeds in that case on reference will await the trial of the action. But on the face of things, he probably would be able to demonstrate that some readers would have understood the sitting MP to be him, although whether there will be enough to establish serious harm to his reputation is, I would imagine, I don't know, but I would imagine an issue that will be raised in due course by the defendant. However, there has also been a determination in the case by a different judge, which is potentially of different significance for the defence. In that ruling, the court assumed that Mr. Bridgen would establish his case, that some readers of the tweet understood it to refer to him, and so it decided in that eventuality what the tweet would have conveyed to such readers about Mr. Bridgen. And what the court decided, in effect, was that Mr. Hancock was expressing a condemnatory opinion about the utterance of Mr. Bridgen, rather than condemning Mr. Bridgen as an individual in his own right. And the reason this may be significant for how the case develops is that Mr. Hancock would appear to be relieved of having to defend an allegation of fact that Mr. Bridgen is an anti-Semite. I should say that it was the anti-Semitic element of the tweet that Mr. Bridgen focused his complaint on. But Mr. Hancock would have to establish that an honest person could hold the opinion that the view expressed by Mr. Bridgen was anti-Semitic. So as the judge herself observed, and I quote, "A reader would readily acknowledge the difference in political discourse between passing judgment on a single comment and impugning wholesale the integrity and morality of the speaker." Now, I've not seen the defence, which has presumably been served, but these two determinations of the court are, I think, an illustration of how early rulings in the English court shape how the case might move forward to trial and may swing the balance of advantage to one side or the other. In this case, I would say to the defendant.
Indeed. So on the subject of defences, let's just have a quick look at what the three main statutory defences are. These are the ones to be most likely relevant to a dispute over a social media post. So firstly, we've got the defence of truth. It's a complete defence to a defamation claim to show that the statement was substantially true to the civil standard of proof, i.e. the balance of probabilities. Secondly, we've got this defence of honest opinion that Adrienne has just been talking about. This is available where the court decides that the statement was an expression of opinion, not an allegation of fact, and the statement indicated the basis of the opinion, and, crucially, an honest person could hold that opinion, no matter how unreasonable or, outlandish it may seem. Honesty is the test. Indeed, this honest opinion defence has been left open as a possibility for Mr. Hancock to argue in the case we've just been talking about. And thirdly, we have a defence which is called publication on a matter of public interest. And with this, the defendant must prove the statement complained of was on a matter of public interest. That looks at the subject matter. And the defendant reasonably believed that publication of the statement was in the public interest. So there are other defences, such as qualified and absolute privilege, but these three are really the main ones we spend most of our time arguing about. And with all of these, it's the defendant who carries the burden of proving that the defence applies.
Well, I would say that there's not much in the operation of these defences that is particularly affected by whether or not the publication in question is a social media post or a traditional form of mass publication, as in a newspaper or broadcast. Although, of course, an impulsive social media posting is not usually the best medium for publishing statements that one might hope to defend with a public interest defence, because of the objective element of the statutory test, which you, Athalie, have just outlined, namely whether the defendant reasonably believed that publication of the offending statement was in the public interest. It's a test with a mix of the subjective and the objective, and the objective is where the court has its say in the public interest aspect of the statement. On the other hand, social media posting may readily have the character of an expression of opinion, and defending defamatory statements as honest opinion has distinct advantages for the defendant, provided the factual basis of the opinion is true and is indicated sufficiently to the reader in the statement complained of. The statutory test to be applied, as you've said, is whether an honest person could have held the opinion on the basis of that fact or those facts. And you referenced in your opening comments the case that Sir James Dyson brought against the Mirror newspaper. Now, that was a case which was successfully defended by the newspaper with an honest opinion defence. It was barely disguised by the judge, at least during the course of the trial, that he really did not think much at all of the journalist's opinion about Sir James Dyson. But of course, whatever the judge's own views, he had to apply the statutory test of the honest man, and that is what got the newspaper home.
Mm-hmm. And as you've already pointed out, the legal rules governing the court's approach to deciding defamation claims were developed by the courts long before the advent of social media. So what do you think are the particular challenges posed by social media libels to these rules that were developed by the courts in the era of traditional media?
Well, some social media cases are perfectly straightforward, and the established rules demonstrably work fine. The Bridge and Hancock case seems to me an example of that. A single freestanding tweet disseminated by Mr. Hancock to his followers on Twitter. So the case would seem to me to have been able to proceed on the basis that every reader of the tweet read it in the same context, so that the court's early determination of the single defamatory meaning conveyed, and that it was an expression of opinion by Mr. Hancock, would apply to the readership across the board. But that is not always the case with social media, and challenges to the current rules for determining defamation claims, and in particular, the approach to determining the single defamatory meaning conveyed to readers on an objective basis and by reference only to a context which is common to all readers, may occur where the libel complained of emerges out, for example, of a string of exchanges between different participants, each with their own followers. So the statement complained of may have been read by different publishees in different contexts or in a different order of exchanges, because what each publishee saw on their own feed and when in time they saw it may very well be different in all sorts of different ways from how other publishees saw the statement complained of in their feeds. But when the court's determining the single defamatory meaning, the general starting principle is that the only context for the statement complained of that matters when determining the natural and ordinary defamatory meaning is a context that would have been seen by all publishees of the statement. There is an option for a claimant to argue that a particular category of readers may have read the post in a particular context whereby that category of readers understood the words in a defamatory sense, not applicable to all readers. It's what we call an innuendo meaning. And similarly to the Bridgen case, where he argued that a particular category of readers would have understood Mr. Hancock to be referring to him. But once the claimant has to resort to relying on a defamatory publication to just a small section of the overall readership, they may, obviously everything depends on the facts, but they may prejudice their ability as a claimant to demonstrate that they suffered serious harm to their reputation.
Yeah, I can see there's a tension there. So basically, there's sometimes an argument that a social media post can be read by different types of readerships who will read and understand the offending statements in different contexts. And I think this kind of argument arose in the case involving Lawrence Fox, the actor that came to trial at the end of 2023.
Yes, and that is the case I referred to earlier, which is on appeal to the Court of Appeal to be heard next month. So in very briefest of outlines and not embracing everything that was going on in that case, Mr. Fox, who at the time had around 250,000 followers on Twitter, posted a tweet critical of public statements by Sainsbury's, the large UK supermarket chain, about its support for UK Black History Month. 3 unconnected individuals who happened to read his tweet, all of whom also had a substantial number of followers, posted responsive tweets along the lines that Mr. Fox was a racist. Mr. Fox then tweeted responses to each of their tweets, calling them paedophiles. All 3 of them sued Mr. Fox for calling them paedophiles, and in response, Mr. Fox counterclaimed against them for calling him a racist. However, as for his paedophile tweets, Mr. Fox was later to explain and argue that what he had intended by his riposte was a rhetorical gesture of protest on his part at being called a racist. In other words, it was his case that he didn't intend his tweets to be understood literally as meaning that they were in fact paedophiles, and he didn't accept that anyone who read those tweets would have understood them in that sense. And what he perhaps should have said, I think this was argued at the trial, but failed to say, was, I am no more a racist than you are a paedophile. But unfortunately for Mr. Fox's case, when the court made its early determination of the meaning of his tweets, the court found that the hypothetical, ordinary, reasonable reader of the tweets would indeed have understood him literally to be saying, in respect of 2 of the 3 he had accused, that they were in fact paedophiles. And as the court pronounced in its judgment, the reasonable reader of his tweets would have understood him to be saying, in respect of those 2, that they were people who had a sexual interest in children and who had or were likely to have engaged in sexual acts with or involving children, such acts amounting to serious criminal offences. So this is a good illustration of the fact that the English court approaches deciding the meaning of the post not by reference to what the defendant intended to say or by reference to what actual readers might testify they understood by the words, but by viewing the post purely objectively through the eyes of this hypothetical reasonable reader in a context that is assumed to be common to all readers. Now, so far, the story, as I've outlined it, is not affected by the fact that this was a social media post, and what I've described so far could, of course, arise in any publication.
So if that's the case, what is it then about this being a social media dispute that you think has lent particular complexity to the case?
Well, the purely social media related argument that was raised was this, and this picks up from my general remarks a short while ago. Whereas in the case of a newspaper article, every one of its thousands of readers will see the same thing, whether it's on the printed page or generally also in the digital version. The readers are also, at least most of them, likely to read the article upon its publication. But then if they only come to read it sometime later, the article and the surrounding context won't have changed. So when the court determines for the purpose of the litigation what defamatory meaning was conveyed to the ordinary reasonable reader, the premise is that all or most readers would have seen essentially the same thing. And so the court's determination of meaning is a good baseline for the future management of the litigation. How grave was the meaning conveyed? What defences are available to the publisher? And if the claim succeeds, the likely level of damages. However, the argument run by Mr. Fox was and will be, as I understand it in the Court of Appeal, that this established approach of the court to determining a single meaning, which presupposes in effect a static publication viewed by all readers from the same source and in identical contexts, doesn't work for social media, where readers see the offending words in all sorts of different contexts, and where the offending words are part of an evolving conversation and seen by readers at different points in time within that conversation. So his argument at trial was that for a whole range of reasons, due to the evolving nature and fluidity of the Twitter conversation in which his own paedophilia tweets were posted, including further posts of his own trying to explain what he was up to, and exchanges that took place after the offending tweets and external news coverage of the incident, all or most of the readers, he said, would have read them in some context or other, which meant that not a single reader of them actually understood him to be making an allegation of literal fact, or as a result of reading the tweets, believing that the claimants were paedophiles. Alternatively, he said, if they did, they very quickly learned that this was not what he had intended to convey. And so he argued any harm to reputation was so transient or short-lived that no serious harm to reputation could have been suffered by either of the claimants. Well, that argument did not bear fruit for him at the trial, and he was found liable to the two claimants and ordered to pay each of them damages for libel of £90,000. Now, Mr. Fox has been given permission to appeal the trial decision, and including the damages, and to renew that argument on how readers of his tweets would have understood them. And it'll be interesting to see how the Court of Appeal deals with this challenge to the orthodox approach of the court to determining a single meaning through the lens of the hypothetical ordinary reasonable reader, shorn of the different contexts that Mr. Fox said were present on account of the social media nature of his claim.
Yes, and I appreciate we are going to run out of time soon, but there have been other cases which have posed challenges because they arise out of social media publications, haven't there?
Well, yes. I mean, it's a challenge, for instance, both for the parties pleading their cases and for the courts, where the complaint relates to, as some of the cases have related, to tens or sometimes hundreds of social media posts. Each of the posts complained of has to be set out in the pleading. A defamatory meaning has to be attached to each. Serious harm in respect of each has to be demonstrated by the claimant, unless they are all substantially at the same allegation to perhaps the same audience. And the court then has to process by the procedural routes that we've been talking about each of these separate courses of action, one after another, after another, after another. And these are extremely burdensome cases for the courts.
Yes, so summing up, it's basically fair to say that defamation cases arising from social media present very considerable challenges to both lawyers and judges, who in some cases have actually used their very eloquent judgments to explain and summarise exactly how particular social media platforms like X work, and that's proven very useful, not just for lawyers. I appreciate we've only been able to give a whistle-stop tour of the key legal principles universal to defamation cases and look at two contrasting specific social media cases. But Bridgen versus Hancock is an example of a case where the traditional rules work fine in the social media context, whereas in the other, the Fox case, the defendant is actually now challenging the application of the traditional rules on the facts of this case. And as Adrienne mentioned, for people who are interested, it's likely the Fox case will be live streamed by the Court of Appeal in July, and I certainly plan to tune into that.
Well, I would just add that if anyone has any feedback about how these kind of cases are litigated in other jurisdictions, or would like to send us any links, I think that would be really most interesting. And certainly for my part, thank you very much for listening, and goodbye for now.
Thank you for listening.